A very good morning to everybody. Welcome to our session. This morning, I'm very privileged that, I have four very esteemed, practitioners who have agreed to help us navigate this very difficult journey that all of us are facing through this COVID-19. And now since that the COVID Act is now officially in place, so I felt that it's very timely that we should be able to come together and share the experiences and also being able to see how we can navigate, a clearer path for our members and also for the contracting parties that we are managing. Okay, so without further ado, I'm just going to introduce to you a few slides just to get the framework of how we are going to conduct this session. So first and foremost, Datuk Ezumi will come in as the first speaker, and he will share basically the areas of the concerns that he has. Many of us have received feedback from our members, also from the stakeholders of the industry. There's a lot of areas of ambiguity, of anxiety, and also, a lot of members are unsure about how we should carry on. So this is the one of the aspects of why we have come together. And then the second speaker would be Dr. Tan Pei Ying. So Pei Ying will cover in very detail the guidelines that we are now currently preparing. Okay, now these guidelines are for PAM members, but currently now it is still, we have a framework, but we hope that after today's session, we'll be able to refine it and be able to issue it to all our members. So she will cover the PAM form of 2006 and 2018, specifically into the impacts of EOT, loss on expense, and all the other procedural clauses that are related to that. And also she will share the Singapore experience, how Singapore has handled it. And then from there, perhaps, you can also take that into consideration. Then Dr. Tan will be covering areas on the new norm. He will be looking into, the good, the bad, and the ugly of how the industry has panned out over the last few months, and how he foresee things might go in moving forward under the new norm. He'll also share some experiences about some of the tenders that he has conducted recently, to our surprise. And also then we will have Lillian. She will cover areas. There's some of the areas that she has covered in her previous CBD, and also specifically, I have asked her to look into how it takes two hands to actually come together to find an amicable solution, not necessarily through mediation, but mediation as an option. Okay, so with that, I will just begin. Okay, now I think this is the timeline slides that I've shared with the PPC, but I think it is still important for us to revisit this particular section of the slide. So I've expanded it slightly, so take your time. We will share these slides to the PAM members, so don't worry about it just coming to you, because the slides are done in the PowerPoint so that you can actually use this in your own analysis or your own presentations. So I think we all knew that in the early of the year, in 29th of February, when the MCO kicked in around 18th of March, kicked in, we had 8 weeks of MCO 1 to 4. Okay, it was a 2 weeks things, followed by a CMCO. Okay, I put in some of these pictures here just to show you actually the political fronts and all the other salient things that happened coincidentally that also occurred with the COVID infection. So over here, then now we are at this stage here, just before the end of the year. I think sometime around June, the government announced that the RMCO will go to the end of the year. But as we know today, the clusters have come in, and now we actually have another CMCO that is extended to 31st of December. So for the PAM form of contract, I think this is quite clear today. We are all past the stage about understanding that the event is captured within our PAM form. So that particular EOT there is actually the 84 days that most of us are quite clear with. However, the emphasis of today's session will actually be on this arrow, which is the additional EOT on a case-to-case basis, which is not so straightforward. And for those who are actually managing JKR contracts or involved in JKR contracts, so this is also an area that are slightly different, because the JKR allows for an additional EOT of up to 30 days beyond the CMCO. But after that, between that, hold on. After that, between the additional 30 days and to the end of the year, the additional EOTs are still also on a case-to-case basis. Okay, something has stuck. Okay, now as far as the HDA is concerned, under the Section 11 of the Act, I think this is quite clear today that the purchasers do get an EOT up to 31st of August 2020, and some of them may actually apply separately to the minister for an extension to their sales and purchase DLPs. Okay, so in the sense that the developers and the purchasers are protected as far as the S&P is concerned. So it's quite well developed here. However, it doesn't mean that there is an automatic EOT for the building contract as far as the contractors involved with this particular construction. So this is an area that we will discuss in today's session as well. Okay, and as we know today, between this period when the Sabah election came in, the local clusters have gone crazy. Okay, and we all know today that the CMCO in some areas you have even EMCO. So this is just some of the information that we have currently today, which I'll come in later part of the slides. You know, and as far as AIC is concerned, is one of the areas that I put up in this slide is because, you know, the dispute resolution methods have been fairly limited. And only till December the 1st, a few days ago, we have a new AIAC director. How that's going to pan out, we don't know, because there's a huge backlog of cases already in AIAC. Okay, so where do we go from here? So I put up here as far as salient points are concerned. So in this talk, we will focus particularly on part 2 of the Act, which is the inability to perform contractual obligations, and part 11, which is modification to the HDA. In the area that we will specifically focus on would be that there's no automatic extension of DLP for the building contracts and the contractors. Now, as we all know, because the COVID-19 is still unraveling, and even as we speak, you can see in Indonesia and in Bangladesh, countries that just our neighbors are having fresh waves, and this will likely go beyond 2020. So in moving forward, even with the uncertainties of the vaccines, we already have the 3rd and 4th wave coming in with fresh localized clusters. So, you know, as we all know today, different areas got different SOPs and different SOPs for different times, affecting additional cost and expense respectively. Now, who pays? We will talk about this, okay? But we all know because of this that there are delays and there's extra costs. So everyone has and will continue to be affected for some time, including you architects, okay? So be mindful about that. So I think it's really, today's session is really to say, look, it is in your best interest that contracting parties avoid dispute, okay? Now, just quickly here, I think these are all available in the Ministry of Housing website. Most of us have got fatigues. We stop looking into all these numbers. We just say, look, you know, whatever. So I've just put in yesterday's readings. As you can see, the different colors tells you the intensity. So if your projects are in this particular area, so how do you respond specifically to your particular SOPs or conditions within your particular areas? So if you look at it, the dark areas, predominantly where our metropolitan areas are, is where the main bulk of our projects are found. So now, this is a question that I like to pose early on, would be the red zones. This is yesterday's red zones. Now, does red zone automatically mean that you have reduced productivity on site? Do you have also increased in SOPs? Likely so, okay? But does that equate to delays and costs? So these are the questions that we hope to deal with today. Now, these are some of the parts that I've extracted off the Wikipedia as far as, you know, this is very important because we kind of lose track about who done what, which announcement, which minister announced what are the flip-flops and things like that. So I think these are very recent. This is only till a few days ago. So you can see that already this is the basis of how the MCO has come into place around August, September, October, November until December. So you're going to see this pattern till January and onwards. And also how this is now becoming an issue where, as we all know, the numbers have all risen in specific areas of the community, okay? So giving rise to the second and third wave. So how do we deal with this? So local authorities have now come out with their own guidelines. So like, for example, in Penang, we got the circulation from our northern chapters that Penang has already issued written directive to all the sites, and that all the pekerja asing needs to do swab tests. And I think Datuk Ezumi will also clarify a little bit more in his slot about some of these SOPs that are coming in January the 1st. And we have also despairing kind of like a worker capacity in Sabah. You can see here, they have made a very clear ruling that only 50% of capacity of workers can work. So, again, this all have an impact on how you as the architect would assess the delays and the costs related to this kind of SOPs, specifically for a geographical location. Okay. Now, also today we have another, stick in the engine here, where the MOH is definitely trying to control the spread of clusters within construction sites. So as you know, the Act 446 is already now in place. So there has been a bit of a resistance and feedback, resistance from the construction industry for projects that are already awarded. That means projects that are running today. How do you go in and start introducing Act 446? You tear down all the houses and then you find new accommodation. It's almost virtually impossible to do that. Okay, so these are the kind of ingredients that are going into this pot of I would say delay events or lead causes leading to further delays and costs. So I think one of the areas that from the outset, architects, this is just purely from my point of view, is that I think a very simple way for one to look into the issues is to just break it down into the 3 M's, which is the manpower, materials, and machineries, collectively affecting time and cost in your projects, okay? But look at it also, the fact that you are also in the same boat, because it affects you similarly in your cost of your manpower and your salaries when you are not collecting fees, okay? So over the last few months, okay, work is not running, but yet your overheads are running. So again, like I said, this is not rocket science. So we hope that common sense should prevail here. Now, this is just some notes first, just to put things in perspective, that the guidelines that we hope to issue after the session today are practical measures, okay? And this is really just in support of PAM's position today in the avoidance of contractual disputes, okay, under these unprecedented times. I mean, we can't stop people going for contractual disputes, but we support the avoidance of it, okay? And these guidelines are meant to clarify and assist our members to navigate the impacts of this virus. And in doing so, I think PAM members must exercise discretion and consideration over their respective projects when referring to these guidelines. But clearly, action must be taken. Architects must do your role. You can't sit back and wait for something to happen. Okay, I think Dr. Tan will have something to add on this. And contracting parties really are encouraged to reach a mutually acceptable agreement by written settlement agreement, because a lot of this would go out of the contract. And again, I said these guidelines may be amended from time to time. As you know, certain events would have passed and so forth. So please, as we go through this here, we would like the members to come in and weigh in as much as possible on helping us to craft these guidelines which are meant for you. Okay, so with that, I would like to move on to introduce the next speaker. Datuk, would you like to jump in?
Okay, Anthony, thank you very much. Assalamualaikum and good morning, all participants and panelists. I'm happy that today we can have all the very important people here as the panelists today. We have immediate past president, Architect Lillian, past president, Datuk Tan and also Datuk Tan Lokman. And Anthony, I have to congratulate you as the chairman of Professional Practice Committee. You managed to bring this into a discussion and to share our views with all the audience. First, I want to mention here that on 23rd October 2020, the government finally managed to get the royal assent for the temporary measures of Reducing the Impact of Coronavirus Disease 2019 Act, which is what we call as a COVID-19 Act. This is Act 8 to 9. So as we all know that COVID-19 pandemic actually causes disruptions to our building industry, delays to construction projects and costs. And this is all caused by the MCO, CMCO, and also the SOP that I think, as we all know, at the beginning of the pandemic, that the government, different agency, different ministry issue different SOP, and it was quite flip-flop at that time. We are all got confused. Then I think a few weeks ago, we had a BIPC workshop discussion. BIPC stands for Building Industry President Council. The members are PAM, ACM, IEM, REDA, Master Builder Association, and RISM. So we had the discussion, how are we going to advise our members, how the industry need to be advised on the implementation of the Act. At that time, the Act was not enacted yet. It was, but we have the bill, the COVID bill at that time. So the major issue is that on the inability to perform contractual obligation under certain situation, the contractors, even the developer may not be able to perform their contractual obligations. So in short, this Act, okay, although that it was released quite late, okay, compared to other countries, this Act in short allow, okay, the provision to be implemented retrospectively. So although that it was launched on 23rd of October, but the effective date actually start retrospectively from 18th of March 2020 and until 31st December 2020. So during this period, this Act temporarily suspends all the contractual rights to the contracting parties with regard to the issues related to MCO and CMCO. So what it says that, okay, if the contractor unable to perform their obligation under this contract due to this MCO or CMCO, then the employer should not exercise their contractual right. So you cannot take legal action during this period. But we do not know after 31st December is this Act is going to be extended or not, and what is going to happen after 31st December. Are everybody going to court after that? So there are two major parts that I want to touch a little bit here. So the first one is part two. Part two actually touches on the issues where related to all form of contractual arrangement, including the construction contract, professional services, even our fees, our arrangement, our employment with the client is also governed under this part two. So he says that if any party is not able to perform contractual obligation, it will temporarily prevent the other party from taking legal action or the other party to exercise their contractual rights. So we know that the purpose of this provision basically to allow the contracting parties to sit down together to discuss and to review how, okay, they can amicably resolve this problem without going into disputes, without going into litigation. So it is important for them to review their position and consider the best way forward, okay, for the benefit of the project and for the benefit of the contracts. So this is where architects, as the contract administrator, play a very important role to facilitate the discussion or negotiation to achieve win and win solutions. So this is where actually when parties come to the architect say, architect, what should I do? Okay, I want to apply for EOT, for example. So architect has to properly advise. So for the architects, for our member to advise the parties, we must understand the provision of this Act and also what are the provision under the PAM contract 2006 and also PAM contract 2018. So in our workshop with BIPC, the main objective is basically to avoid disputes. So rather than going for a dispute resolution, we say that our approach supposed to be dispute avoidance. So whether it is arbitration or adjudication or any form of litigation, we try not to go along that route, but try to sit down together, even at a cafe, coffee shop, how to mediate this formally or informally. So if we are talking about formal mediation, the Act also allow the provision for mediation. For other contracts without the provision of mediation, the COVID Act actually opened a solution, a new solution, which provide the provision for mediation. But of course, under PAM contract, both PAM contract 2018, 2006, the provision for mediation is already in the contract. In PAM 2018, mediation clause is clause 34, and PAM contract 2006 mediation clause is clause 35. So our PAM contract pretty much covered in terms of provision for mediation. But however, okay, this mediation that we are talking in PAM contract is more like a formal mediation. But I would like to encourage our members to take the approach of informal mediation. If you can resolve this, okay, at the meeting table or at a coffee shop, please resolve this, get both parties to sign a piece of paper, say that, okay, we agree to this, we agree to the recommendation by the architect, and always we have to allow, or we must suggest that solution which is fair to both parties. And of course, talking about formal mediation sometimes the process can also be very lengthy and also can be costly. But to facilitate our members, okay, at PAM we also provide this service. If any of our members, if any of our members need assistance to mediate the parties in their project, they can always contact PAM. So they can contact our ADR or PAM secretariat. We provide a venue for mediation at PAM. We also provide a mediator if the architect is not able or refuse to mediate the situation, then they can have the mediator appointed by PAM, so that if you are in this situation, you can always contact PAM. So our role as the contract administrator is very, very important. So it's not just the architects and other consultants as well, including the engineers, even the QS. So this is where the architect as the lead consultant need to encourage other consultants as well, including the engineers and also QS, to be practical, to resolve the dispute, okay, in the practical way. And not just to exercise the right suing each other, but how to make sure that the situation can be mitigated and then solution can be done amicably. So there have been calls from the construction industry and also our member asking for guidance in resolving contractual dispute arising from this pandemic. So I've received text messages and also phone call, emails asking is PAM is going to give guideline, PAM is going to help us to evaluate the EOT and asset claim for loss and expense. So this is where I think today, our forum today is very important, so that we have prepared the the guideline, I think, for the last 1.5 months, but hopefully that after the session today we can finalize this. So consultant, you need to play facilitative roles, and we must help. Okay, we must help the parties to resolve the problem. So among the issues that being asked by members are how to give EOT when contractor does not submit claim. So this is one of the earlier question that I received. So if the contractor do not submit claim, can we still give the EOT, or we just wait until everything is over? And then the other one is that should the CMCO period be given EOT as well? They say that they are very clear. The MCO period is considered as the force majeure. EOT will be given. But what about CMCO? Contractor can work, although in half capacity. So how will I evaluate? Should I give the EOT, or should I give EOT half of the duration because they work only 50% of the capacity. And there's another question. I give EOT under force majeure, but contractor claim expenses for SOP compliance. Should I allow this or not? Then can PAM help to mediate? Is PAM going to give guideline how to assess EOT? So there are a lot of questions, and even on the contractor side as well. The contractor also asks, okay, I have not been paid. Contractor say I have not been paid, but can I suspend the work? There is provision under the contract that if I'm not being paid more than 2 months, I can suspend the work. But now the COVID Act say I cannot exercise that right. Is that true? So I cannot suspend. I have to continue work even though I am not being paid. So this question came from the contractor. So basically, EOT for sale and purchase agreement, okay, is given automatically. If you look at under the part 11 of the COVID Act, it says that from 18th of March until 31st of August, then automatically EOT will be given for the sale and purchase agreement between the purchaser and the developer. Okay. However, okay, the defect liability period, everything will be extended accordingly for the sale and purchase agreement, but not the construction contract. So the construction contract, the EOT is not automatically. So the contractor said this is not fair. Okay, when the developer and also the purchaser receive the EOT automatically, and we are not given the EOT automatically, but we still have to attend to this, and we have to bear all the costs on our own. So there are a lot of issues. So generally, I would say that for extension of time, the assessment for EOT we must take into consideration on the delays, the progress of work, okay, because which is caused by MCO and also CMCO, not limited only to the MCO. MCO is straightforward, but CMCO, I think you have to do assessment. So how does the CMCO impacted the work progress, impacted the contractors? The same thing with the compliance with SOP. Due to compliance of SOP, the capacity of workforce need to be reduced, and then the testing for COVID at the earlier stage, it was very difficult to get the testing. You have to queue, wait up to 1 month before you can get the testing and test result. The same thing with precedent condition, which is required under AOT. So the contract say that there's a precedent condition that the contractor must notify before EOT assessment can be done. So, but under this situation, I think we cannot be very strict on that. We have to waive certain condition under this situation. So, consultant, I would recommend that to assess EOT application regardless if the contractor do not comply with the provision precedent about the notice for additional expenses and other things related to EOT. Because under this situation, sometimes it's very difficult for contractor to comply. Okay, and the same thing with loss and expense. If the contractor is granted under the EOT, the contractor is granted EOT under the MCO based on the ground of force majeure, the contractor is not entitled for the loss and expense claim. But we have to understand, under this situation, we have to reconsider, okay, because when the contractor participate in the tender, during tendering, nobody can foresee this pandemic is coming, neither the contractor nor the employer. So if we strictly say that this EOT is under force majeure for the whole duration, and then the contractor, you cannot claim for any of the expenses and losses, then it may implicate the contractor, the work progress, and probably the project will not be able to complete at all. So this is where actually it is recommended for all the parties, including the consultant, contractors, and also the developer, to sit down together, at least to agree that the cost from the delays due to MCO should be shared by both parties. So this is where, as architect, we have to play very important role to facilitate the discussion. So at least if they can agree to share the cost, that reduce the burden at least by half for both sides of the contracting parties. So any claim or certification for EOT or loss and expense which have already been issued or submitted prior to the Gazette of this Act shall remain valid. Okay, that one shall remain valid and shall be processed in accordance with the provision of the contract, unless if both parties agree to waive a certain condition to it. Okay, so however, whatever I mentioned here is not a one solution that fits all problems. So I think after this, Datuk Tan Pei Eng will share all the detail with slide explanation or what I have mentioned here. In fact, I have been discussing with Datuk Tan Pei Eng, Architect Anthony, also Joseph Tan on this guideline, but we don't really feel comfortable to release it 1 month ago. We believe that we have to study further, look into further detail, and I hope that today you all give feedback to Datuk Tan Pei Eng as well after this presentation, so that if we need to fine tune, we will fine tune it, and hopefully after this session, maybe by next week, we will issue to all our members. So Anthony, I think I end what I want to say here. So thank you very much. Back to you, Anthony.
Okay, thank you, Dr. Ezumi. So before I just hand the session to Dr. Tan Pei Eng, just to have an overview again of what Dr. Ezumi has said, I think in short this is what we are saying about common interests over individual rights. I mean, look, if everybody is going to sit down and start saying, look, my contractual rights, so this is, I think, it's going to cause more troubles, and you end up not having projects completed.
Yes.
Now, the other thing is also the point that Dr. Ezumi has made is very, very important, is that the architects should bring in the quantity surveyors and also the engineers, because you know, I've spoken to many projects, and sadly a lot of the architects are looking at the QS for opinions and decisions, and this is a very dangerous precedent, with all due respects to my QS colleagues. But I think, you know, the habit of asking the quantity surveyor to give his contractual opinion, it's just going to make things very complicated. Okay, yeah. So so I think this one, Dr. Tan will also weigh in later. The other one is the engineers, because, you know, the M&E works, again, you know, M&E works are really in difficulties because of all the equipment. They're stuck in ports. They're stuck in, you know, in different countries. Equipment is very straightforward, but then a lot of these are under NSEs. So I think this is where the engineers can come in and look at things, and you'll be surprised when you sit people down. Although now we only allowed to have 2 persons, Datuk Ezumi said go to coffee shop, but coffee shop you only got 2 per table now, right? So you need to join the tables a little bit further, and then you know, have these sessions. Okay. So with that, Dr. Tan, can I hand over the session to you?
I was just texting President Ezumi. He has summarized almost my whole presentation, so maybe I don't need to present anymore.
No. You got to go through your detailed slides. Yeah.
We still want to see the details.
Yeah.
Can you see the screen?
Yes.
Okay. Yeah. Anyway, good morning. Yeah. So my presentation this morning will be divided mainly into 2 parts. The first part is actually on the provision of the COVID-19 Act 2020 in relation to the construction contract. And the second part is on the recommendation proposed by PAM on contract administration with reference to PAM 206 and 201, a form of contract. Okay, as you know, the long anticipated COVID-19 Act has finally been published only on the 23rd October 2020. So I've included in this presentation the portion of the Act that deals with construction contract, which is under Part 2, inability to perform contractual obligation. Okay, there are altogether 6 sections under Part 2 of the Act, from Section 5 to Section 10. Construction contract and professional services contract are included under Item 1 and 3 of the schedule under Section 7. Okay, I will share with you an extract of a recent presentation by a lawyer, Mr. Chan Keng Ho from Chong and Keng Ho, on the COVID-19 Act to the Building Industry President's Council, focusing on Part 2 of the Act so that you can have some understanding on the provisions. There are 3 important points covered under Part 2 of the Act. 1 is inability to perform contractual obligations. 2 is dispute resolution by mediation, and 3, saving for exercise of rights prior to the publication of the COVID-19 Act. Section 5 stipulates that Part 2 of the Act is deemed to have come into operation on 18 March 2020 and will expire on 31st December. The Minister has the authority to extend the validity of this Act part before the expiry date by order published in the Gazette. Based on what we are facing now with the third wave, I suspect this will be extended. Section 6 is interpretation, and the minister named in this Act shall mean the minister charged with responsibility of law. Section 7 of the Act is on inability to perform contractual obligations by the parties from the categories of contracts specified in the schedule. Under the schedule, as highlighted earlier, construction contracts and professional services contract are included under item 1 and 3 of the schedule. This section also specifies that the inability to perform the contractual obligation must be due to COVID-19 measures to control or prevent the spread of COVID-19, and the contracting parties shall not exercise their respective rights under the contract during the said period. This means that there's no reprieve against the parties from exercising their rights under the contract for those issues not relating to COVID-19. If the inability to perform is due to COVID-19, then, for example, the employer cannot call on the board, cannot determine the employment of the contractor, set off, etc., and the contractor also cannot suspend his work or determine his own employment. I also wish to highlight that the Act only provides a temporary suspension of the rights of the parties for a limited period. Currently, that's from 18 March to 31st December, unless further extended by the minister. It is not a waiver, and it is also not an automatic extension of time of 9.5 months. It is important to note that the COVID-19 measures cover not just the MCO period, but also CMCO, RMCO, EMCO, and all the SOPs imposed to control and prevent the spread of COVID-19. There were many dialogues and discussions conducted among the industry stakeholders, and whilst there seems to be some consensus regarding EOT during the initial MCO period, the EOTs to be granted for the delay caused by the subsequent COVID-19 measures are much more complicated and depend primarily on the specific conditions affecting the project and the contract provisions. So all the SOPs imposed by the government and authorities definitely affect the productivity that resulted in delays and increased costs on the projects, which have implication on all the stakeholders along the value chain. There's this constant conflict between the contracting parties. On one hand, employers do not want EOT and loss and expense to be entertained. On the other hand, the contractors are requesting for EOT and loss and expense to be granted. But this COVID-19 pandemic is unprecedented, and our current contract may not have provided provisions to ensure fair distributions of risk, as this is quite unexpected. As such, we as contract administrators are now expected to step in to take on a more proactive role to mediate and to mitigate the conflict in order to minimize the impact on the ongoing projects for the benefits of all the parties. Section 8 of the Act is on the power of the minister to amend the schedule by order published in the Gazette. Section 9 is on dispute resolution by mediation. So any dispute on the inability of any party to perform any contractual obligations due to COVID-19 measures may be settled by way of mediation. Please note that this is a may provision and it is not compulsory. And the mediation process, which includes the appointment of the mediator, role of mediator, and conduct of mediation, may be determined by the minister. And upon conclusion of a mediation, the parties shall then enter into a settlement agreement in writing. The settlement agreement shall be binding. Okay, Section 10 is on saving provision. It stipulates that any contract terminated, performance bond forfeited, legal proceedings, arbitration or mediation that have commenced, judgment awarded, etc., during the period from 18 March until the date of the publication of this Act, that is 23rd October 2020, shall be deemed to have been validly carried out. So I wish to reiterate again that Part 2 of the COVID-19 Act only applies for disruption of contract due to COVID-19 measures. As such, the rights of the contractual parties remain intact if the breach is not due to COVID-19. But with the saving provision, even if the breach is also due to COVID-19, actions taken prior to 23rd October is still deemed to be valid. Okay, just now as President Datuk Ezumi has highlighted in his briefing, the building industry stakeholders have acknowledged that this COVID-19 pandemic has caused major disruptions to the building industry. So it is also clear from the presentation that the COVID-19 Act would not be able to resolve all the issues that the building industry is facing, and disputes are expected if it goes strictly according to the contractual provisions. So the mediation process provided under the Act to resolve contractual disputes will be very lengthy, costly, and also time-consuming. So recognizing that COVID-19 pandemic is unprecedented, so the BIPC have decided to work together to address these concerns by providing advisory notes. The intention is to encourage all the contracting parties to approach the ongoing projects with a fresh mindset by looking at how best to preserve each party's interests, as opposed to insisting on strict contractual rights. So what I have projected on the screen is the Building Industry President's Council joint advisory notes that were jointly prepared, and it was issued on the 13th November 2020. So I want to highlight the key recommendation in the said advisory notes. You can see the arrow, so maybe it's a bit small. Consultants are encouraged to play facilitative roles in helping the contracting parties to explore options that will seek to balance their respective interests to ensure the sustainability of all stakeholders and the building industry as a whole. So the construction industry is now looking at us and expecting we as architects to take the key roles. So these are all the signature. Okay, before we discuss what are being recommended by PAN, let me share with you the recent development in Singapore, which could serve as a very good reference and guide for us. Singapore government has just passed an amendment to their COVID-19 bill on the 2nd of November 2020, which just came into effect at the end of November 2020. Okay, this is a circular issued by the Singapore Building and Construction Authority to explain on the amendment to the said COVID-19 bill. Okay, so there are two main reliefs that have been introduced for the construction sector to provide more support and to ensure no single stakeholders bears an undue share of the burden imposed by COVID-19. So A is to provide a universal extension of time of 4 months, which amounts to 122 days, to address delays for construction contract. And this applies to not only the government sector, but also the private sectors. This extension of 4 months will be applied automatically. You don't have to apply. This would therefore give the contracting parties more breathing space. It allows consistency of treatment across all the affected construction contracts and provides certainty and assurance to the industry as they restart their projects. But according to the BCA circular, this EOT will not apply to those construction contracts where the contractors actually carry out the work during the period from 20th April to 30th June. So contractors who wish to seek longer extension beyond the 4 months can also negotiate with the developers or rely on the existing contract provisions. They could also serve a notification for relief to seek defense from LD payable under the contract due to delays sustained during the period starting from 1st February 2020 to 31st March 2021. So although you have a universal extension of 4 months, there are still provision for you to apply for more. And the part B is a very interesting provision. B, they actually require the co-sharing of additional non-manpower related costs, which they call as qualifying costs, between the contracting parties due to delay caused by COVID-19 for projects under both public and private sectors. What it means, the co-sharing percentage is 50% of the qualifying cost. The qualifying cost will not include the manpower, and this is going to be shared between the contracting parties, meaning 50% for the contractor and 50% for the developers. But this is subject to a monthly cap of 0.2% of the contract sum per month and a total 1.8% of the contract sum until 31st March 2021. This relief measure is to ensure that no stakeholders bears an undue share of the burden caused by the pandemic and minimize the downstream contractors going under that could in turn knock-on impact on the entire value chain. So in the event there's any dispute, an adjudication application could be also made with the BCA. So Singapore COVID-19 bill has clear provisions to deal with EOT and co-sharing of the cost, which our COVID-19 Act lacks. So PAMS has prepared and submitted the following recommendations to be considered for construction contract administration to BIPC. These recommendations have yet to be discussed and agreed upon, but I will brief you on what we have proposed. I think this has also been summarized to a certain degree by President Ezumi, but I will still run through with you. The first one is on the extension of time. As you know, the delay caused by COVID-19 pandemic and COVID-19 measures are considered as force majeure, and the contractor is entitled to claim for EOT under relevant event under clause 23.8A of PAM form of contract. And I have highlighted in red what we mean by force majeure. Under AD of Article 7 means any circumstances beyond the control of the contractor caused by terrorist acts, government or regulatory action, epidemics, and natural disasters. So for the project that has not been issued with CPC, the assessment of the application of EOT shall take into considerations the delay in the progress of work caused by COVID-19 measures that include the MCO, CMCO, EMCO, and all the compliance of the SOPs imposed by the government and the authorities. The timeline presented by Anthony earlier serves as a very good reference on the period and factors to be considered in your assessment of EOT. For example, the requirement of testing before workers are allowed to commence works, social distancing, restrictions on the number of workers permitted to work, travel restrictions, affected material delivery. All these will affect the productivity and will delay the set progress. And all these must be considered in the EOT assessment. We have also proposed to waive the condition precedent requirement for EOT application for delay caused by COVID-19. So consultants are recommended to assess the EOT application even if the contractor has not complied with the requirement on the notice and the particulars of delay for EOT. This is covered under, I think, clause 23. Okay. So the next item is on loss and expense. As also explained, as per the provision under PAM form of contract, EOT granted for delay caused by COVID-19 is based on delay event under force majeure. And as per clause 24.3 of the conditions of the contract, the contractor is not entitled to claim for loss and expense. But we want to recommend for the parties to agree as follows. Each party shall pay for their own costs arising from COVID-19 SOPs compliance, and employer shall bear the cost for the extension of performance bond and insurances for the EOT granted in relation to delay caused by COVID-19 pandemic, because the cost for the performance bond and the insurances are actually protecting the employer's interest. So we think that this additional cost should be borne by them. So as also explained for the defects liability period, so based on PAM form of contract, there's no provision whatsoever for the DLP to be extended. But under Part 11 of the COVID-19 Bill Act, DLP for the house purchases have been extended. So that's why we are going to recommend DLP for the projects they falls under the DLP period to be extended as follows. For projects not regulated under HDA, so to be extended for the period affected by the MCO, and for projects regulated under HDA to be extended for the period affected by the MCO and part of the CMCO, which is from 18 March to 31st August 2020. This is basically to tie in with the period granted under Section 36 of the COVID-19 Act. And item number 4 is other contractual obligations that have time implications. When we went through PEM form of contract, we realized, there are a lot of obligations under the various clauses that have time implication, but there's actually no provision for extension. So as such, we are also recommending for the duration of the contractual obligations of the parties, which fall under the COVID-19 measures, to be extended for the same duration with the MCO period, where all of us are under lockdown and we cannot even go to the office. For example, period for final account, period for insurance of interim certificates, period for compliance with instructions, period for issuance of list of defects, period for making good defects. Actually, there's a whole list, which I will run through with you in detail later. So what we are saying is the act of delays in performing this obligation during the period affected by the MCO shall not be considered as defaults by the parties. So just now what I presented are the summary of the key recommendation. Now I will take you through the detailed clauses under PEM 2018 form that have time implications which may be affected by the COVID-19 depending on the stage of project that you're in, and our proposed recommendations which are highlighted in blue. Okay, Article 3, 4, 5, and 6 on appointment of new consultants within 28 days. So this will be extended for the period affected by the MCO. Okay, subclause 1.4, contractors' written notice on discrepancy or divergence between documents. So this one to be extended also for the period affected by the MCO. Subclause 2.4, failure of contractors to comply with AI, the time frame to comply also to be extended. Okay, the period stipulated under subclause 3.3, 3.4, and 3.5 for various actions also to be extended. For subclause 4.3 is on conforming to statutory obligation, the period of written notice to be extended for the period affected by the MCO. And subclause 6.5D, work not in accordance with the contract on the submissions of method statement, this one also to be extended for the period affected by the MCO. And subclause 11.5, 6, and 7 that stipulate various time frames for actions by the respective parties regarding valuation of variations and the period to be also extended. Subclause 15.2, 15.4, and 15.6 also stipulate various obligations and time frames for architects and contractors to take actions. And these are also to be extended for the period affected by MCO. And all the periods stipulated under subclause 16.1 on issuance of certificates of partial possession and release of retention fund to be extended. And there's no need to recommend extension for clause 19 as the validity of the insurance will need to be extended to tie back to completion date and DLP as stipulated. Okay, again, for clause 20.A, B, and C, relating to insurance, there's no need to recommend for extension as the validity of the insurance would need to be extended to tie back to completion date and DLP as stipulated. And subclause 21.1, commencement and completion is related to EOT. Subclause 21.3, sectional completion dates is also related to EOT. And then subclause 21.4 on postponement on or suspension of the works. So please note that the suspension of work due to MCO is not considered as a period of delay that entitles you to determine the contract. Okay, I think, sorry, I missed one clause. Subclause 22.1 and 22.3 are also related to EOT. I think for the extension of time, the recommendation and on the assessment has already been presented earlier, so I will not repeat here. Okay, for for the submission of notice on the particulars for EOT under clause 23.1a and 23.1b, this was also presented earlier, but I want to highlight again. So we are basically proposing to waive the condition precedent requirement with regards to the submission. But however, this condition precedent shall still apply for delays which are not caused by COVID-19 measures. So I have also highlighted in red the actual provisions under the PEM form of contract. Okay, for subclause 23.3, insufficient information, period for architects and contractors' action to respond for EOT application not related to COVID-19 to be extended for the period affected by the MCO. And for subclause 23.4, certificate of extension of time, architects' action on notice of rejection or issuance of certificate of extension of time to be extended also for the period affected by the MCO. And subclause 23.10, period for architects' review of EOT after practical completion to be also extended. Okay, clause 23 is on loss and or expense caused by matters affecting the regular progress of the work. This has also been presented earlier and I will not repeat, but I just want to highlight for subclause 24.1, the condition precedent requirements with regards to time frame for submission of written notice and submission of particulars by contractor to claim for loss and expense incurred by matters affecting the regular progress of the work under clause 24.3. This period also to be extended for the period affected by the MCO. But under force majeure, they are not entitled to claim, but for all the other delay where EOT are granted, right? So we still need to assess the loss and expense, but we need the time frame to be extended. Okay, under clause 25.0 on determination of contractors' employment by employer, there are many subclauses as highlighted that have time implication with regards to notice, period to comply, and all this shall be also extended for the period affected by the MCO. And under clause 26 on determination of own employment by contractor, again, there are many subclauses. They have time implication and the period to comply, and all those shall also be extended for the period affected by MCO. For NSC, the period of objection, payment, and compliance under subclause 27.2, 27.5, and 27.6 to be extended for the period affected by MCO. And for nominated suppliers, the period of objection, release of retention fund, payment under subclause 28.2, 28.5, and 28.6 also to be extended. So I think this is a very important clause, certificate and payment. And this under this, there are also many subclauses as highlighted that stipulate various obligations and time frame for notices, periods for compliance, and actions by the various parties. So the recommendation is also for them to be extended for the period affected by the MCO. And clause 31 on the outbreak, this is not applicable as there was no outbreak during this period. Okay, I think this one was also highlighted by President Ezumi just now. Our PEM form of contract actually provides for various alternative dispute resolutions, including mediation, expert determination. Expert determination only applies to the 201A contract, arbitration, and adjudication. So there are also several timeframes stipulated under these clauses related to notice and procedures on the appointment. So if your projects are having these provisions and get caught in this situation, so all the timeframe will be extended for the period affected by the MCO. Okay, so I also wish to highlight, although the COVID-19 Act has provision for mediation for dispute in respect to the inability to perform contractual obligation due to COVID-19, it is a May provision, so the contracting parties can also rely on the contract provision for all these disputes to be resolved. So subclause 38.2, the time frame for notice deemed to be extended for the period affected by MCO. Subclause 39.3 on the validity of performance bond, and subclause 39.6 on time frame to return performance bond are also related to completion date. So there's no recommendation. So the last part of the contract will be under the appendix. For the defects liability period, I've highlighted the following recommendation earlier, so I will not repeat. For the period of delay under clause 21.1 and 26.1d, the suspension of work again is due to MCO is not considered as a period of delay. An interim claim interval, period of honoring certificates, period to complete final account, all these recommended to be extended for the period affected by the MCO. So basically, we have come up with all these recommendations. It may not apply to your projects because it all depends on the stage of project that was in. But all these recommendations we have already submitted to BIPC, and we hope the BIPC and the industry stakeholders will endorse and adopt what we have proposed. We need to fine-tune them after our deliberation and discussion. And like President Ezumi has said, we would like to come out the final practice notes to be issued to all the members as advisory notes. So I would like to reiterate again, this is indeed an unprecedented pandemic that affects all of us. We as architects and as contract administrators will need to take a lead role. We need to work together and stand united on this so that we could mitigate the impact collectively. So let us work together to make a difference. And thank you and stay safe. Thank you.
Thank you very much, Dr. Tan. That was a very comprehensive set of slides. Thank you very much. I think we have to also give appreciation to Dr. Ezumi and also Joseph, Architect Joseph Tan, and yourself, Dr. Tan, and having sat down and prepared this guideline some time ago. So I think this is the few points that you have brought up. I'd just like to revisit some of the points here for our members here. It's very interesting, the matter regarding the Singapore experience, because although the Singapore experience is not gazetted or applicable in Malaysia, but because parties, we are recommending for parties to sit down and work out practical solutions. There's nothing to prevent parties sitting down and referring what our neighbors are doing. Because when you look for settlements, you find practical settlements. So so that's one of the reasons why we decided that the Singapore experience is useful. At least that you are not going off tangent, or you are doing something very, very it's what I like to call Dr. Tan, very maverick. Okay, yeah. So it is being done in Singapore, and I think it's very well articulated. So rely on that. But again, like I said, bringing parties to be aware that these are kinds of a middle ground that people are moving into. The other thing is also, it's very interesting that because part 2 also involves architects, and part 11 says, look, the purchasers get an automatic extensions of DLP to their project. So that essentially means that architects, you're also out of pocket, because now, instead of you wrapping up the project earlier, now you have to hang around longer, right? So you see, it impacts you in a way that, look, sometimes we don't quite see it when the thing is right in front of your face. So, I always just want to bring it back to the real world, to us, how we are actually part of subsidizing this problem. So we are part of whatever we settle, whatever we try to bring parties together to look at, to be practical for a practical solution, involves also a solution for ourselves. Okay. So,
and maybe just to highlight, in fact, in one of the dialogue that we have with the Minister of Works, we actually highlighted to the Minister's attention that our COVID-19 Act, the provisions under Part 2 is actually quite lacking. And now with the Singapore experience, and in fact, he actually said we can maybe come up with a proposal to be submitted to the government for consideration. I don't know whether it's too late, but with the Singapore experience, maybe, while we come up with a guideline to guide our members, we should also concurrently pursue with the Ministry of Works to see whether there's any way for the Act to be amended to emulate what Singapore has done. So it will make life so much easier for everybody. I like this universal extension of time of 4 months. So it takes away so much uncertainty, At least you have 4 months being granted for all the projects. So we don't need to do the assessment. We need to do only assessment for those which are not affected by the COVID-19. Yeah.
Datuk Tan Peing, I think maybe we can prepare a proposal. We can always submit, because even if you look at the Singapore experience, they didn't include that in their first act. They only included it in the amendment. So I think I think we can make a similar proposal. We can write to the minister, and let's see how the response of our government, because I think it will save a lot of time and resources, especially when everything is considered as time frost, time freeze. You don't need to submit the application. So I think something that we can.
So when we were preparing this guide, we also realized actually our PAM form of contract, we have so many clauses which has got time implication, but there's actually no provision for them to be extended, because we'll never expect this kind of lockdown, complete lockdown, or what they call the circuit breaker. So maybe we should also look at amendment to our PAM form of contract to introduce clauses that actually allow some of this obligation to be extended.
Well, just before I hand over the session to Dr. Tan, I think Joseph Tan has posted a very good question here. And I think this is a question that is, I don't have the answer. He says removal of precedent conditions here, not an issue for MCO, but what about RMCO and CMCO? So maybe
let me explain why it was only recommended for MCO. Because MCO, we were all being locked down in the house, we were unable to work. But during CMCO, we have access to go back to the office, so we are still able to be to access, and the contractor also has got access to the office to actually prepare all these. So to be fair, I think the condition precedent waiver should be given only for the period affected by the MCO. But we are open for discussion. So this is only our initial thoughts.
Okay, because the real impact is actually now, because, and it's going to drag on even longer than the actual lockdown. So that's why I think Joseph's question is very important for us to address, so that we don't leave the gaps there. Okay.
Right.
So with that, I'd like to introduce Dr. Tan. Dr. Tan, can you can I hand over the session to you? Doc, you are muted.
Not too small.
Doc, you are muted, Doc.
Good morning, everyone. Thanks for the very good sharing. I was asked to share a bit about the way forward, and as well as that, I want to also share as a professional architect what we've been doing. I think, while we are going through this whole period, I look at it as a great opportunity for architects to shine. In the whole of the PAM contract, all these contracts, the architect is the contract administrator. We have a lot of say. And if you look at the way we've been operating in our offices, I dare say that we are so busy now as compared to even normal times, because we have to take a proactive role. And when you look at the contract and our role in it, we cannot just sit back and let time flow through, because it will only get worse and worse. So we can see that our COVID bill will end on 31st December, likely to be extended, but don't wait for it to come until 31st December before you start addressing issues. Okay. So going forward, I just have a few points. I think we need to look again at what a contract is. It's like a part 3 question, but there was a valid offer, adequate consideration, and acceptance. I think the key word in all contracts and contracts going forward is it must be fair. And as architects, as contract administrators, if you got only one thing you want to follow in your guiding principle throughout this whole period of making decisions, mediating, bringing parties together, I think the keyword is to be fair. Okay, and as long as you can be fair, not biased, your client pays you, yes, but you are supposed to be a fair administrator. So I was actually asked by Anthony, we've been quite busy also with new contracts and tenders. Surprisingly, we thought it would be a very quiet period after the MCO, but we've actually let out quite a few tenders. And when we were looking at the PAM form and also FIDIC contracts for overseas, we actually tweaked it a bit and put in some new clauses, because we cannot say that we don't know anything about COVID. It's already there and we've been through it. And it is likely a recurring event. If you look back, it's 100 years ago, and then you have had two other incredibly bad pandemics after that. So it's like a recurring event rather than an unknown event, okay? So number one, with our contracts that we're going forward, we reinforce the concept that all contracts must be fair to both parties. We have also put in let the buyer beware clause, or caveat emptor, meaning that we've put it all on the table. For Malaysian contracts, we have put in the Act 446. If you haven't put it in yet into your tender documents, you must put it in. It's $50,000 fine per worker. Okay, it can wipe out your whole job. Okay, and nowadays it's not so easy to be settled, these sort of things. So you got to put in the workers' accommodation, and that's related to COVID as well. Another one is we have put in all the COVID and whatever mutation, whatever forms of mutation that's going to come out, all the SOPs, all the testings, and we won't put there that if your staff are not they're tested positive, they cannot come onto the site. So all these are written into our new contracts. We don't leave it out anymore. And the third one is prevention and eradication of diseases. That means you got to fumigate, you got to clean the place, you got to disinfect. All of these are written in. And contractors today, when they tender for new contracts, they got to come in with their eyes open. So it's let the buyer beware. But I was asked in our short discussion before this session, the tenders must be coming in very expensive, with all these measures. To our great surprise, I think it's because everyone needs work at the moment. Tenders are coming in way below they were like even last year. And we are getting prices 10%, 15% lower. It could be the situation where people need jobs and they need to just give away some profit, but that's currently where it's at. So future tenders, you must put in all these clauses. We have redefined force majeure. Okay, force majeure means any circumstances beyond the control of the contractor caused by terrorist acts. Last time also don't have terrorist acts. It was war, right? Governmental or regulatory action, epidemics or natural disasters. And we have added in a sentence, but exclude the aforesaid circumstances that can be reasonably foreseen by an experienced contractor by the date of submission of this tender. That means when you're going through a COVID period and you're tendering and you get the job during a COVID period or pandemic period, you cannot say that it's force majeure and you don't want to start work, So it is clearly stated, and we have actually done modifications to that. So force majeure, I just want to say, when you give inclement weather, EOT, it's something that is outside of the 100-year chart or 50-year chart. This pandemic is coming back like every 100 years, and maybe it is something that is not so inclement after all. And that's where we have adjusted the force majeure clause. So barring international and national government directives or events, all others to be priced for risk, meaning that, and this is the policy we have done for EOT extensions and also for payment of loss and expense. If it's a government directive, we will consider it. If it is your company SOP, because you are multinational from Australia and you've got incredible SOPs, we will not consider it because it's unfair to the parties. Fair and competitive market-driven tendering. I think, again, I re-emphasize the word fair. And because you go through a tender process, it must always be competitive. That means that, and we are seeing that exactly in this downturn or in this market, we are actually getting very good prices and good for our clients, I guess. Yeah. I cannot emphasize more this last few. Real parties to contract. We are starting to find contractors, especially from one of the largest countries in the world, starting to use sub-companies. That means their mother company is a Fortune 500 company based in a foreign country, super contractor. But they use a company that has an addition to it. So they say that it's Asian or international or something like that. But actually it's a very small subsidiary. I think contractors are also smartening up. That means when they go into a tender like that, where they go with their eyes open and they know that there could be a major effect in a year's time where they need to close down shop. You need to really look at that. And especially also for your NSCs. NSCs will walk away and you can frustrate a contract. So I think the last two are clearer definition of frustration. I think we'll start to see more and more of it. We are starting to see curtain wall companies that are already folding up. And so once a company folds up, the contractor can claim that he can no longer perform the job and the contract can be frustrated. But we are tightening up some of these clauses. And these are actually not in the PAM form itself. It is in the additional clauses you put into the tendering. I'm also looking at, we are drafting exit clauses. Haven't come up with a good one yet because it is very dangerous to have exit clauses, but we also think that sometimes our clients also need the exit clause. And I think the whole thing comes back to my initial first word, that it must be fair. And we are coming into a period where the architect has an incredible opportunity to take back the lead in the industry. Everyone is looking back at us because every time they look at it, it's the architect who needs to make a decision. And I know that many people have been calling us and we've been saying, wait for the COVID Act. The COVID Act is out already. It's time to make some decisions. Even if you don't make a decision on the spot, write down some pencil notes. Don't leave it in the too hard basket. It is not going to go away. Write down some pencil notes, start to make some decisions. Don't send it out first. Think it over. And I think one of the things that I've been very proud of our practice or practices, we have very few cases where we have gone to court, whether with our clients or with our contractors, very few. And I also don't like to go to mediation and I don't like to go to arbitration. I find that the moment lawyers get involved, it becomes very complicated. So we have a chance to shine. And as architects, I mean, you heard from Paying and Ezumi, everything in the contract comes back to us. And all it needs for us to do is to be fair. It's a contract between parties. Nobody's going to die. Some companies might wind up, but it is not a knife to the throat thing. We can sit down and be fair, and they are looking to us for direction and leadership. Okay, so thanks very much, Anthony.
Thank you, Doc. I think you know what you have just raised. We can have a whole new Kesabana series on COVID, because I think the part that the part that currently where our PAM form of contract, you have just hit the nail on the head. That perhaps this is an opportunity for us to produce a totally different concept of a PAM form of contract, where it becomes the contracting parties come in openly, willingly, and they sit down and negotiate terms, rather than negotiating prices and meeting specifications. I mean, like we say, if you go into a willing buyer, willing seller contract, why not? Because, every job has its difference. So parties sit down and apportion the risk. So, I think this is definitely something that we can look at, because like you say, it's not going to go away. And not going away and living with COVID, really, the elephant in the room that we often ignore is actually the biggest pandemic that we actually lived with even before COVID was in fact the mosquito, which is the dengue mosquito. You know that, there are more deaths from dengue mosquitoes and dilapidating a disease from dengue in Malaysia and our region than even COVID. But we live with it. We go out, do we worry about wearing a mosquito repellent when we go to the sites? But, we live with that. And we know of many, many people who die and get dilapidating problems with that. And if you get a mosquito, a dengue mosquito or any mosquitoes in your construction site, the authorities shut you down for a week. So I think that we have lived with that. It's almost the norm. How is it that we can't live with this? So I'm confident that eventually, we are very practical, and I think that it's a matter of moving ahead. So with that, I like to hand the session to Lillian. Lillian, are you there? Lillian? Oh, okay. Lillian? Hi, Lillian. Yeah.
Oh, hello.
Yeah, hi.
Hi.
So Lillian, I'll just give you a moment to get ready. If you're ready, you just let us know. Then you can just put up your screen share. Yeah.
Yes, please, if you can put it up. I think Salam has them.
Salam, you can put up.
Good morning, everyone. Good morning, everyone. I think first, thank you, Pei Ing, the PPC team with Anthony and Joseph, and of course, Dr. Ezumi, for the very, very thorough coverage of all the issues on COVID-related impact to our contracts and to our industry in general. I think being the last to speak, I think everything has been covered, so I'm not even sure whether there's so much to add, but I do have some slides and I could just quickly recap them and touch on the topic I've been asked to cover, which is how to try to facilitate mediation and resolution between the parties as the architect and contract administrator. I think way back at the end of July when this started, I did that was before the COVID Act came out. So that was a good 3 months since, 4 months earlier. Of course, at the beginning, we did immediately recognize that the PAM contract was the only one of the common building contracts used in Malaysia that set out very clearly the condition we were facing with COVID-19 as epidemic situation. In fact, more than epidemic, pandemic. So whereas the other contracts didn't. I'm sorry, I'm at home. Let me just close the door. My dogs are barking.
So I think like while we are waiting for Lillian to set in. Oh, okay, she's back. Okay, I was just about to take a few questions. Yeah.
I think it's the newspaper man coming by or something. They do that.
Not the milkman. Huh?
No, the milkman have stopped going the rounds for a long time. They probably, maybe it's the Grab guy, or the Lala Move. Okay. So as mentioned, of course, we had to. Well, I would say we have to use it, this as the clause, even though there are possibly 2 other clauses to use. Okay, next, Salam. As mentioned, the JKR contract, the PWD 203A, does not specifically, it includes a force majeure provision, but did not specifically mention pandemic as falling into force majeure factor. And the FIDIC Red Book as well also sets out conditions that will describe a force majeure condition, but not actually mentioning epidemic. So clearly, I think in a way, our PAM contract had foreseen in a way that epidemic situation will cause that type of crippling and disabling of works on a large scale, in fact, national level, that we had seen with COVID, which I would say is unprecedented in Malaysia, even though, as Dr. Tan had mentioned, there does appear to be some sort of a cycle that we have seen, some 70 to 100-year cycle, with the last major one being the Spanish flu. So while these clauses in the PAM contract, I mentioned 23.8A, that's a force majeure, 23.8P is the clause on compliance with changes in new regulation, compliance with any changes to any law, regulations, or bylaw, and from any appropriate authority and service provider. And of course, there's also the suspension of works or part of the works by order of an appropriate authority, provided not due to any negligence or omission on the part of the contractor and NSCs. But however, all these 3, where we could possibly park the extended time, the EOT, does not have any corresponding provision in our clause 24 for loss and expense. Okay, next. Sorry, Salam is doing my screen sharing. Okay. I think Pei has already gone to quite detail about the conditions precedent that would normally be required of the contractor to post notice within certain days. I think Pam earlier, until we had the COVID Act to make clear that the suspension of rights on such matters, we did advise members at that time to give to remind their contractors to give notice, just to be clear. But I think it is good, as already discussed earlier and proposed by our PAM practice committee, that contract administrators should also allow applications that come in that did not comply to these conditions precedent to be assessed during this time. Okay, I think also I see a question in the chat also from Joseph, which is a very important question to differentiate. The MCO and CMCO period is really originally from 18th of March up to 9th of June, where we practically did experience almost complete lockdown, where the entire economy almost came to a standstill, with the exception of certain industries that were allowed to apply for permit to operate through MITI that regulates industries and manufacturing, and including also construction works. So in essence, even though there was a major national lockdown and suspension of works, general suspension of works, many industries started to operate to some extent, of course not to the full operating capacity, sometime from early March.
Lillian, may I just interrupt you? Because in the interest of time, perhaps you can just probably cover this quickly, because I think this has been covered already. So sorry to interrupt you, but perhaps in the interest of time, you can leap forward into the areas that we discussed. Perhaps you can jump in and add to the issues of bringing parties and ideas of mediation. Yeah.
Okay, Salam, can you just move to the timeline? This is the chronology. I think it was across unprecedented conditions, and because of change of government, because of that we had never experienced such a situation, that the SOPs and regulations that came out, public health regulations, of course, in retrospect, perhaps were somewhat inconsistent sometimes, and also seem to be still evolving. Okay, next. This timeline, which I would like to just recap again for this period that we called MCO, I think Pei Eng generally has referred it to MCO, is technically earlier thought of as the end of the MCO and CMCO, because the RMCO was thought to commence from the 10th of June. However, with the COVID Act, they have given the period all the way up to 31st August as the period that may be excluded from the calculation of VPLD, basically the period that the delay due to the pandemic would be looked at. So I think we need to make clear, if we are using this full period, which is 167 days all the way to the end, basically for the automatic extension, so-called. I think the thinking of it, of course, is that if the developer, the employer, basically would be enjoying this extension of 167 days, given it should, in fairness, be carried back to back with parallel contracts, such as the building contract. I think that's a point that should we keep in mind when we assess, because the period after this is, as mentioned earlier, the difficult period. Okay. Next. These are, of course, the documents are already, I don't need to look at that when the government made their own decisions. So, okay, next. Let's skip that. Salam. Yeah, and the next one. So I think there indeed will be a lot of onus on the service, on the architect to facilitate, even though there's provisions for mediation in the contract. I think it's something that that still will be slow. As you know, even though PAM also has facilities for mediation, it has not really been prevailed upon very much. And there will be, I think the lawyers have set up as well, mediators to mediate conflicts arising from such delays. But the first step really should be to encourage both parties, facilitated by the contract administrator, the architect, to exercise, to basically be fair-minded and to be able to co-share some of the cost that neither party had seen. Okay. I think, sorry, go back to the last one, Salam, previous one. Okay. So in the COVID Act, there are basically 3 clauses that relate directly to building contracts. Section 34 regarding late payment charges, where developers shall not impose late payment charges if the purchaser fails to pay installments for the period. So this is a relief for the purchaser side. As Section 35, delivery of VP and liquidated damages, this relief is given for the period, those 167 days all the way up to 31st August will be excluded from the calculation of VP and LD. And the developer may also apply for additional extension past this date up to 31st December. But I wanted to emphasize that this is something that when they apply for this to KPKT, they will have to fill up that form, which I showed you earlier, which includes for the developer to submit a corresponding extension of time certificate from the architect, and also includes a statement from the architect to inform what would be the estimated completion date to enable KPKT to make that additional extended time. So this is where the duties of the architect is very clearly stated, where we will have that duty to estimate what would be a fair amount of additional time beyond the 31st of August. So this is an onerous duty for us to ensure that we have made a fair assessment of the delay, because it will be needed and used by the developer for additional time between the 31st of August and the 31st of December, which is a total of another 122 days, besides the 167 days. I think another area of dispute that will come up is because the developer will be getting extended, the DLP period, and of course the purchaser may also apply for the extension of that DLP period, further extension if they wish to, which is quite messy because they may come in and apply at different times, and therefore you can't close the whole period of defects liability. So, which means that the purchaser's DLP period may extend past the contractor's DLP. I have seen on actual projects that contractors, of course, are keen to just finish and quickly get out because there is no specific requirement or provision for them in the COVID Act that their DLP is correspondingly extended with the extension of DLP for the purchaser. And therefore, developers obviously will have to honor the extended DLP at their own cost if they're unable to agree with the contractor to similarly extend the DLP period to cover defects rectification for the purchases that could be prolonged beyond the original dates. So I think this is one of the points to look for the architects will need to help to facilitate where the contractors, to get the parties to agree to a corresponding extension of the contractor's DLP period to follow the extension that would be given to the to follow the extension to the DLP period from the extended VP period. And of course, I think architects will also be asking, of course, that they themselves will also suffer prolongation costs due to all these prolongation of contract administration during this period. So I think these are some of the issues that will come. Some other general issues that I think we should, as PAM, be urging is that, as we can see during this, with the new clusters coming up during the RMCO period, a lot of it is due to construction clusters and the need to improve worker housing moving forward. I think is very critical, and we should continue to press for the enforcement of it. I suppose because of this, I looked and I didn't realize that we actually had legislations to set out minimum standards for workers' housing as far back as 1990. The Workers' Minimum Standard Housing and Amenities Act, 1990, Act 446, and amended as recently as 2019, sets out worker housing requirements down to the size of a minimum size of a bed and the spacing of a bed. So a lot of the very stringent SOPs is related to these huge spikes that can happen, mainly from such a thing as workers' housing that needs to be addressed. Singapore was able to manage that spike very quickly because the government committed to improving worker housing very intensively during that period. And I do think that we should also press for such longer term issues. Of course, you know, it will translate into slightly higher costs for the contractor in the future, but it is something that is already stipulated in the law and needs to be adhered to. That's also the very reason why in Singapore, for the sharing of costs excludes costs related to labor, because this is something clearly within the duty of the contractor to provide. So I think moving forward, we can expect that this cost will create incremental costs to construction and property in general, but that's something that perhaps we should have happened long ago if the worker housing conditions were enforced. But moving forward, to prevent the type of spreads that happen, that cause further suspension of works, this really needs to be enforced urgently. So that's something that I think needs to be called for. As mentioned by Anthony, I think there is good wisdom for parties to try to come together to agree on co-sharing some of the direct and indirect costs due to compliance costs mainly. I think PA has said very clearly costs of things such as the extension of performance bond and the insurance should be borne by the beneficiary, which is the employer. So that's quite clear cut. But some of the costs of compliance can be quite high. You know, each time you do a sanitizing of a mid-sized building, each sanitizing can cost 20 to 30,000. we have one project in the office where they were incurring costs of around 300,000 just to have all the workers sanitized and the building sanitized and the workers to be tested. So that's obviously a compliance cost that should be put on the table to be negotiated between the parties because this is a cost that's really neither foreseeable by both sides, the employer nor the contractor. Okay. We are also happy, of course, that the AIAC will soon be appointing the new director after it has been vacant for quite a while. But I'm sure that there will be a huge backlog of cases, especially payment claims and payment disputes. So that will also help for parties to go to that route, should they so. But I do hope that all parties will urge that parties come to the table to resolve and the architect to play a role to facilitate these sharing of costs for some of the costs incurred by mainly the compliance costs, excluding, of course, costs related to workers' housing, which clearly is something that should be borne on the contractor side. I think that's all, and I'm sure there are lots of questions that we should.
Okay, so thanks, Lillian, for your part of the sharing. I'd like to now move on to take some of these questions. We've received quite a few questions. So can we stop sharing that screen? Okay, thank you, Salam. So maybe I'd like to just take on a few of these questions here. And then as we answer these questions here, then we can go back into some of the guidelines that we have suggested. And perhaps, from there, we can take more feedback from our members who are here. I think I'd like to just jump in on the item that is still fresh here, which is really the contractor's role in when the housing the extension for the purchasers go into the DLP. I think one of the questions was posed here. So Datuk Ezumi, maybe you would like to weigh in on that. And then after that, I'd like to hear from Dr. Tan as well.
Okay, I think under the COVID Act, it's an automatic extension under the Housing Development Act. So that is considered that from 18 March to 31st August, so automatic extension will be given. I think more or less about 80 days plus, okay? Or maybe more, I can't remember. So, but the issue is that when the developer must accept the extension, that they must serve the purchaser for all the defects. But in the construction contract, there is no provision for that. So this is where I think what I'm going to suggest that this is where we should consider to get the agreement by both parties, the employer and also the contractor, to consider the same. So because if the default ability period for sale and purchase agreement is extended, and if the contractor appointment is not extended, then the developer need to get other party to come and to rectify. And this is just for a short duration of period only. It will be better if the contractor can continue for the work which was done by them earlier. So that's why I think what we want to recommend that the default ability period for construction contract should also be extended in accordance with what was recommended under Part 11 of the COVID Act. So that's my view.
Dr. Tan?
This is a very real problem, and we're really inundated by questions on it. Actually, it's interesting that the moment you issue your CPC under the building contract, you've got no more room to issue any AOT. It's already done. You're finished your job.
Yeah.
So to extend a defects liability period actually when the developers come to you or the contractors come to you, they are really respecting you as almost God, you know, administrator of contract. And the key word is to be fair. We actually don't have a role to extend it or not. We can go to government and recommend, but if the government doesn't do it, I think you just have to advise the both parties. And we have basically gone for sharing of costs. I think it's not fair to, you know, the law, that's why we keep very clear. If it's a directive from government, both parties share costs. If it is not a directive for government or in a gray area, I try to make it as fair as possible and I try and sit the parties down. Or now that Beijing has shown the Singapore model, where there's, you know, if you can apportion some way the cost, because when you say you apportion the cost, the contractor will dump in a lot of costs. Okay, things that are not even there. So I think maybe if you can look at a bit more at the Singapore model, I don't know much about it, but if we can come up with some figures and come up with a fair proportion, it might not be 50-50. It might be less or a larger portion to the contractor, etc. But I think the key word is to be fair. But I take it as a compliment from the industry that even though they know our role under contract is over, we cannot extend, we don't have the powers to extend EOT for DLP, but they are still coming to us for a decision. And as long as they trust us to make a right decision or recommendation, I won't hesitate to do it. Because if it goes into arbitration, it goes into court or something, or worse still, the contractor refused to rectify, and I get the leaking problem and apartments get knocked out, then the problem, you know, is the leaking tap problem. And it gets worse and worse, and the cost gets even bigger. So we're given a chance, we'll be proactive and we'll make a quick decision. We were waiting for the COVID Act, because before that, we didn't dare to make any decisions. Now that it's out, I think it's quite clear, what is gray. And when it's gray, if you ask me for my opinion, I'll give you my opinion, and I'll try to be very fair about it. Yeah.
Thank you, Doc. I think the area, coming.
No, I'm just saying that most of the contractors will be quite willing to extend, although there's no provision. Because when your project is already into defect liability period, you know, the defects doesn't come out all of a sudden right up to the end. You know, a lot of them would have came out during the duration itself. If your project is already at the tail end, a lot of the defects would have been taken care of. Even extending it by another few more months, I don't think it's a major issue. You know what I mean?
Yeah.
So
it is not just that. In some situations, the contractor even couldn't get the workers to come. So that's why sometimes the contractor also need time to be extended. Because when
but Izumi, if the defects has already been known to them before the expiry date, right, and they could not get worker to come, the list is still kept alive, right? The contract provision, the certificate of making good defects will only be given after all the defects that you have highlighted, you know, within that period are made known to them, right?
What I'm trying to say that if there is no extension, but if the contractor couldn't rectify during the given period, then the employer has right to employ other people, the third party, to do it and charge the contractor. So that's why I say in certain situation, the contractor also probably prefer the extension, so that give more time for them to arrange for the rectification work.
So the only thing, of course, you know, by extension, it's basically acting unilaterally. As an architect, you know, you want to avoid to be acting unilaterally to change the terms of the contract, which really you don't have the ability to do that. And this, again, we are saying to bringing the parties together, having a very, you know, practical views of looking into the issues. After all, for housing, I particularly feel that because for housing, it's really in your best interest to go and do it for contractors, because you know, you don't really want to end up having, you know, having to go in even when people would have moved in later. It make things a lot difficult. But the area that I want to address in this extension of DLP to contractors is that it's not so clear-cut when it comes to, for example, like the release of retention sums of money when cash flow is already very tight, when, you know, contractors need money to pay people and they have spent a lot of money over this COVID period. So these are the kind of balance, you know, checks and, you know, like the fairness that what Dr. Tan was saying about being fair, bringing parties together. And also about the equipment warranties, where you have equipment that, that comes with the NSCs and all that. So what the contractor may agree, the NSCs may not necessarily agree. And things like extensions of warranties and all that, they're all things that it's in the same basket. So this is where I think the earlier advice given by Datuk Ezumi about the architect having to now really take the role where you have to bring in the QSs, bring in the engineers, and bring in the contractors, even the NSCs and all that, and put everybody, put all the things on the table, and really having to deal with this.
Anthony, just to cite an example, Kisah Benar, we took, when the CMCO was announced for Klang Valley, Selangor again, we were doing soil investigation in a project. And the owner, it was a bit of confusion. I also thought that you couldn't work in office anymore. So I packed up and went home. But the next day we went back to office. But that moment of confusion, the client asked the SI to demob, okay? And then later on, they found out that if they could actually work, with SOPs and so on. So when they got them back in, there was a big mobilization cost, remobilization. This is just like the past few weeks, all this happened. And engineers sometimes they are quite slow to make a decision how to deal with the additional costs, and it just stuck there. So I was very happy that the client actually agreed from day one, said we'll share 50-50, offer it back to them, because they refused to come back on site. So if they refuse to come back on site, number one, we lost time, and et cetera, et cetera. So I think the key is you must be very proactive at this time. I think all who are in practice today, is every day you have to solve things, and you've got to be really taking the lead. It's a great opportunity for us to shine. And the engineers sometimes, because they don't normally administer contracts. So this was actually under him, and he was very hesitant to do it. So we actually prompt it a bit, try to prompt it, and then the client also offered straight away, because otherwise it was a stalemate. So I think those are examples that I think we need to be very proactive, keep short accounts, try and sort things out every week, if you can. Yeah.
Now, one of the areas that I just I realize in the industry is that many architects, and this is purely from my own observation in the various hats that I wear, is that I think many property developers, even very, very large property developers and architects, have not been exposed very much to loss and expense claims. Although we say it quite frequently these days, but it's a term that's not really been used a lot. And most of the times, I think that architects will tend to move to the QSs and say, look, okay, there's a compensable delay event. But I think in this case here, architects really need to jump in and understand the concept behind a compensable delay event or a non-compensable delay event. In this case here, the delay events under CMCO really falls in between all of this here. I think it's important that maybe perhaps, we in the Kisah Benar series here, we should be doing a series on a short talk about loss and expense, what actually they are and what actually they are not, because, most of the time I know, even from my own personal experience, one of the largest property developers in Malaysia, I would say, they have been doing a lot of housing, and they have never paid a loss and expense ever in all of their years of being a property developer. Okay, so so this, even from the employer point of view, it's like, what you mean? What do I have to pay? What is a compensable delay event? So I think these are salient, very salient, important things that the terms are being used very often today. But I think the understanding of it could be quite narrow. So is there other questions that particularly that we want to address? Because in the Q&A, I think that there are two main categories of questions. One, I think we've dealt with just only on housing. Can we maybe move a little bit further into some of those questions? Can some of the panelists take on any particular question that you have seen that you would like to jump in on under the Q&A area? Ezumi, you've had time.
I have responded in writing some of the question in the Q&A, and I think we have also discussed on the question just now, except that I think Joseph gave a very good feedback here on the, when we say that on the sharing cost for the loss and expense after EOT was granted, I did mention that it is good for architect to facilitate the discussion, so there will be cost sharing. But what Datuk Tan Pek Eng presented just now, we didn't include cost sharing for the preliminaries and administration, but we just say specifically for the insurances and bond that the employer may have to bear the cost. In our view, the reason why we say that, because that is the cost for payment to bond and insurances, which is going to be benefit the employer. But all the contractor's own costs, including the cost for the staff, site management, utilities, that is the cost for sustain the operation of the contractor, should be covered by the contractor themselves. That is our view. But of course, the Singapore model actually they resolve it differently by cost sharing, including the operation as well, other than the cost for the human resource for the workers. So that is something that we may look into it, but I don't think it is easy to achieve that. I think it's not easy to achieve agreement by the industry players. So that's why I think we have to, I would like to agree with what Datuk Tan Pek Eng presented, that maybe only for the insurances and bond, which directly benefit the employer, then employer has to cover that cost.
Datuk Ezumi, maybe we can go a bit further. We can recommend that as a base, but I must also admit there are some developers who are actually quite generous. Like for my project, even though under the contract they don't have to pay, but because they know that it has greatly impacted the financial standing of the contractor, they actually help to also pay some of the testing costs and compliance costs. So there are developers in town who are prepared to do it. So maybe we recommend the base, and we say, you know, we can also suggest for the parties to sit down, and if they can agree to share part of the cost, you know, it will be great.
Yeah, that's why I think for our guideline, I think what you have presented just now, I think just fine, but we can always say that, okay, if the party agree to go further, it is even better. And I like to respond to what Dr. Tan mentioned just now. I think similarly in Singapore, originally when they want to implement the 50-50 cost sharing, they thought that they want to implement for the government project only. But after that, I was informed after that, they decided to implement for both the government and also the private project. So I think when the government implemented the HDA, automatic extension until 31st August, the purpose is basically for the protection for the interest of the purchaser. I think that was the intent, because the purchaser, they do not have to pay the installment or the stage payment and so on. And of course, it benefit the developer as well. But it does not mean that the government want to totally ignore the contracting party outside the HDA in the construction contract. But maybe, I think, in my view, the government leave that part on to the professional actually to administer this, compared to the sale and purchase agreement, because the purchaser may not have that knowledge and may not know what are their rights. But at least for construction contract, it is administered by the professional. So I think government will be happy for the professional to help administering these issues and resolving the issues. So I think we should take it as something that which is good, that the government trust the professional can administer this properly.
Maybe I can just supplement what you said. I was told by the lawyer, because the contract is, the government can change the law that is under their control. But contract is not under their control. It's basically a contractual relationship between the two parties. So they cannot, according to them, impose a requirement to vary the contract conditions.
Of course.
But I don't know how Singapore did it, but Singapore government must have got consent for them to do it.
The company.
So,
the question here, I'll try and answer it. Dr. Tan, what is the tender price that's coming lower in this period? What is your thought that the price is fair or sufficient, i.e. to cover the acquisition SOP, considering that the provision for health and safety in the prelims have always been loosely looked at and priced or even underpriced? What's your advice? Okay, I always believe that we go through a tender process to make it competitive. And when we put our tender, when there's no contractor appointed yet, we only have one person we are responsible to, which is our client. And we have to protect the interests of our client. That's why we have drafted or clauses to protect our client in a contract. And I mentioned in my talk, very simple, you got to make sure the contractor is legit. He doesn't use a company number 6 that is a subsidiary of a subsidiary of a subsidiary in thinking that it's going to wind up. So you got to check get a good contractor. And what we are finding is we are getting good contractor, competitive pricing, eyes wide open, buyer beware, adjusted force majeure, adjusted, put in all the clauses for maintenance, the workers' quarters. But the other thing you must do is, we also notice that contractors are also very smart. Sometimes they put in things that the site doesn't need because they are preparing for EOT. So in one of them, that really good contractor, he put additional tower cranes. And what you have to do is to be very careful, because later on, when you go into EOT claims, the tower crane is not something you can say isn't there, because it's always there. And as long as it moves, they can justify that it's operational. And tower crane claims for loss and expense is actually high. So these are things, as an architect, the first thing is, while you're tendering, you must protect your client. The moment you have appointed they have gone into a contract, you have to be fair to both parties. I think that has not changed. And I thank Pei for mentioning again that government in the end cannot intervene with private contracts. And that's where the person who can intervene with private contracts is the architect, not even the QS. Okay, so we have a very important role, and we must step up to the plate. It's a great time for us to shine. Yeah.
But the government can come up with directives to direct us.
With minimum standards or directives, it will help us a lot, because there are
correct. I think we should pursue that.
I think there's a question here about the SOPs. Supposing, I think this is going to happen a lot more, where contractor has done all the SOPs, and then, somebody catch COVID in the site, and then, the whole site gets shut down again. So, so what happens? I mean, this is real. I mean, I've seen situation where it's like the mosquito again.
This one Paying got to answer.
Yeah, you got a mosquito as well. No, I mean, I've had
one, because we also kena. They follow the SOP, full compliance, and still kena lockdown AMCO. Then what do you do?
Okay, maybe just to share with you.
Go ahead.
Maybe just to share with you our recent conversation with SIA. It was quite interesting how they actually try to mitigate the spread even within the site. They also know that it's very difficult to control, the workers from getting it. So what they do is they create bubbles. So although it may not be so productive, but they actually create bubbles. So if that small bubble, somebody get infected, right? But the rest of the site is still intact. So at least you mitigate the impact of that spread. And according to them, they also have this, instead of a lot of our activities are parallel with each other. They talk about, sequential kind of activities to allow groups to come in, move out, So basically they create small bubbles. So maybe this is something that especially in view of the recent spread, we have a lot of clusters happening at the site, and the whole site gets shut down. Maybe these are some of the things that the contractors should look at. Not as productive, but at least you mitigate the spread, and you don't have a total lockdown situation.
No, I think that's a physical thing. But what happens if it has happened? How would an architect administer that? They say, the contractors, clearly it's like the mosquito problem. The mosquito is found on the site, but it's flying in from everywhere. The mosquito is not living on your site. Yeah. And it is exactly the same situation. You get locked down. Is it your responsibility? You see, I think these are real questions where do you issue EOT? Who's responsible? This is where I don't have the answers, honestly. So I'm hoping that perhaps we can sit on this. And
I mean, if the contractor is caught being totally irresponsible in not complying with the SOPs and all those, it's
straightforward.
Responsible.
He he's leaving his butt open. But then if he's
Lillian wants to share something.
yeah.
I think by now the SOP is much clearer, Anthony. You know, KKM has already issued when a person is positive through contact tracing and interviews, internal interviews, you establish the first circle of direct contact. That's the only layer, that tier of people in direct contact with the one person positive that needs to go for swab test, right? And immediately needs to be quarantined. And of course, the second and third tier needs to quarantine only, but no need to go for swab test. So I think this mechanism certainly helps businesses right away, because what I notice is when something like that happens, everyone in the company or in the site just panics because out of just fear of contracting. When actually the system is set up very clearly now to manage the numbers of the actual people. So your period of shutdown will be much reduced, and now you get your test results within 24 to 48 hours max. So I don't think we should be seeing the type of long shutdown when people are not sure and everybody is just not allowed to come to work. So so the contact tracing and managing and keeping track of the workers on site or people in the office is very important to mitigate the amount of shutdown time should one worker or one employee get tested positive. Because it's I think it's part of the new normal that we need to adopt that practice to mitigate the delay, because you will never know where these people come from.
Thank you.
Often you just
I think
attending a wedding and something like that. So it'll be hard. So I think the implementation and understanding of the tiering of risk is very important to reduce delay time.
Dr. You want to say something?
No, having said that we should be proactive and we gotta be fair, I don't want to leave that question unattempted.
Yes.
What happens when a EMCO is imposed on your construction site? I think I would address it as a professional. I would, number one, solve whatever has caused the problem, mitigate any spread, identify, trace, do all the things that are necessary. Then when it comes down to contractual issues, if it is the government will come and do the EMCO, there will be a directive to your site. So I will follow my principle. I'm not saying it's right or wrong, but I'm just telling how I would do it, because I cannot just sit by and not do anything, because the client will be asking me, the contractor will be asking me, subcontractors will be coming to me, the NSCs. So I will look at it and I'll follow the principle that I've been using. If it is a government issued a notice to EMCO and barbed wire my site, then from that period on, it is similar. Actually, EMCO is worse than MCO. They have to bring food for you. You cannot actually go out and buy food. So I would take it that it's a government directive and it goes into that force majeure period where both parties share their own costs. I would look at it that way. But if it is proven that you did not follow the SOPs and you got it into that kind of a problem, then I would look at it differently. So I think I would go down that line, but maybe you can hear from the others. We cannot not think through a process.
It all depends how the EMCO is being imposed. If it's a clear contractor's fault in not complying with the SOP and they have been very sloppy, so to me it's not fair for UT to be granted due to their default. So I don't think there's a one size that fits all. You need to study the individual condition to find out how the spread came about.
I think the thing is you have to start thinking. You cannot leave status quo.
I think it's not only start thinking, but it's really bringing the parties together and say, look, if this happens, this is what I'm going to do. And so don't preempt. It's a preemptive thing now. Before the thing happens to your site, do the preemptive things. Put up your SOPs within those SOPs to say, look, like I said, the mosquito example is one. If your site is well treated, there's no water ponding and all that, and somebody find the mosquito and the authority come in and find the larva in there, you think that is fair, or mosquito flies into your site and, so that's where I think that we already have the system in place. It's just that now the disease is different, Yeah. I want to take this, because we don't have much time left, I don't really want to take the Saturday morning by everybody. So it's been quite a long session for us. I just want to take this question on back to the loss and expense during the CMCO. So is this the position that we're taking now with the guideline, that the loss and expense and the is related basically to the EOT, because we may be granting EOTs based on case-to-case basis. And if those EOTs are fair, so therefore some of these would be compensable delay events. So in some of these compensable delay events is the position that now we are advising our members in our guidelines is that the cost should be shared, and some of this cost should be paid by the developer, like insurances and renewal of performance bond. Where I just want some clarity here, because there's a question here by Al here that I think we should address. Bing, maybe you want to jump in on this?
No, which where is the question? I think we have just now mentioned, we have given our recommendation. If the EOT is granted as a neutral event, that's not covered under clause 24.
Yes.
Yeah,
that's during the lockdown.
Yeah.
I'm saying so, after the lockdown.
After the lockdown for EOT.
Yes. Yes.
Or for EOT granted. Yeah.
Yes. After the lockdown. Yeah.
I mean, if the EOT is really due to COVID-19 measures. You see, the Act talks about COVID-19 measures. It didn't really mention MCO, CMCO. These are all COVID-19 measures to try to prevent and control the spread of COVID-19. So maybe we can look at that. EOT granted even during CMCO because of the delay in the progress of the work, right? Although they're not entitled to loss and expense, maybe we can apply the same recommendation for the extension of insurance, extension of performance bond for the employer to pay because they benefit from that. So maybe this is something that we can look at. Yeah, we can readjust our proposal. I think what we can do is after maybe we should set up a meeting among ourselves, maybe somewhere early next week to run through some of the questions and then debate among ourselves and finally come up with the final proposal.
Yes. Oh, I just saw Joseph volunteered himself. He brought his hand up. Yeah.
Oh, that's good.
Yeah. Thanks, Joseph. Yeah. So I think one of the areas, because we're getting some questions here, I think we have to consolidate the questions because the questions are coming in. Some of them are like, scenario questions. I think we should, it might be beneficial if we maybe do a FAQ. Do you think that we should prepare a FAQ along with that guideline?
Yeah.
Like I say, we are all new to this. So it's good to get as much feedback as we can so that at least whatever guideline will come out is more practical. So there may be issues that we have not addressed. Yeah.
Sure. So I like to kind of bring this session to a close now, unless the panelists have any burning issues that you all want to say, because we already past 12:30. In closing, I just like to maybe ask for any last words from the panelists here. Dr. Tan, maybe I start with you. You're muted, yeah. Dr. Tan, you're muted.
You turn on your mic.
You're muted, yeah.
Sorry. I think just to remind everyone to be a good contract administrator, honesty, integrity, and to be very fair.
Okay, Lillian, would you like to have any last words?
Yeah, I would like to, perhaps all our discussion had been focused on building contracts, housing, where the developer, which is under HDA. There are many contracts out there that architects are administering that are not under the HDA. Could be office suites, service apartments, where therefore the process for the developer to procure the extended time will not be through the KPKT process. So I think in those cases, architects should ask for information, because you won't know between that developer and their purchasers what would be the additional extended time for delivery of vacant possession. So that's because the process is not regulated. So I think our advice to our architects committee would be to advise the parties to follow basically the benchmark. What's stated in dealing with housing contracts regulated under HDA is, of course, setting the benchmark. And we should have that principle of all non-HTA regulated contracts that we administer should be encouraged to follow.
Thank you, Lillian. Paying, Tan Paying, any last words?
I would like to augur what Dr. Tan has said. We as architects must take a lead role, and we cannot be shy away from our responsibility. And by being fair as a basic principles, is going to help us to solve a lot of the issues. So end of the day, you know, we are being tasked as a quasi-arbiter in the contract. So I think we play a very important role. So, and end of the day, let's all work together to make a difference, like I said. Yeah.
Okay, Dr. Ezumi?
Okay, Anthony, I think two things that I want to mention here. First, in assessing the EOT, although that we are going to issue the guideline, but sometimes you have situation when the EOT application submitted is beyond what mentioned in the guideline, neither maybe not due to force majeure, due to other things, but also related to COVID. Okay. So in this situation, although that you may have difficulty, okay, in assessing the EOT, even the loss and expense claim, my advice is one thing. I always learned this from my previous CFO and partner, Jerry Sam. He said that, okay, you just try at your best ability to assess it fairly, and you must have basis. Don't simply plug the figure from the sky. You must have basis for your justification. Rightly or wrongly, it can be debated later, but you must have a basis for it. And the other thing that I want to mention, I think we discussed about the construction contract, and I saw that there's one question: what about the architects? Okay, under this, can architect claim for additional fee for the prolongation and delay in the project? I think, like when I start the discussion today, I did mention that we all have to work together as one. I think if your developer are super rich, just go and explain to the developer saying that you need to help me. I need to sustain my operation as well. But everybody are in difficult situation now, then we have to understand each other. If we can survive, I can continue to survive, and developer also in very difficult situation, I think we probably have to let go our right in certain situation for the survival of the project. So just work together as much as we can, hoping that the next project will come back to us and we can do better. So
thank you, Datuk. Yeah. So in closing, I have a few things that I would like to share with the members. First of all, I would really like to ask you all to share through PPC your Kesa Benar stories, good, bad, and ugly. I mean, you can leave out the details, but really we need to have data. We need to have feedback from the industry. And the more sharing of good settlements will actually encourage better settlements, because, you know, we have to pave the way forward. So we have to take this as a positive, mindset that we can actually do it and we can actually find settlement. Because like I said from the beginning, it's in your best interest, it's in our best interest that parties do not dispute. Even the lawyers have said, concentrate on buildings, not billings, okay? Because they the lawyers will start billing, you can't do buildings. Now, the other one, in closing, I really like to thank my co-chairs and also in PPC and the committee members for having been very, very supportive of this year's initiatives. And also a special thanks to Mimi. She's been very patient with me because I have a lot of activities going on this year. So there's been a lot of effort being done in the background before we can actually do a simple session like this. Now, in closing, I have actually a last slide that I wanted to put forward. Can I just do the screen share? Okay. Can you all see that? Excuse me. Can you all see my last slide?
Yes, yes.
Okay. Now, today's session is actually a pre-forum for the PAM PPC Forum edition 13. I think it's edition 13. I'm not quite sure. I have to check it with Mimi. It's a round discussion. It's not really a full, like a normal seminar, obviously, because of the CMCO. It's been extended.
Sorry, Anthony, can you full screen? Thank you.
Full screen. Okay.
Slideshow.
Okay. All right.
The slideshow.
Okay. Coming. Okay. Got it.
Okay, thank you.
Okay. So, because this session that we are doing is actually to create the fodder, to create the framework and structure and really what we're going to do with this roundtable. Now, this roundtable discussion, we have some very interesting people who have agreed to join us. So the first two names there are very significant people. So, we'll be looking into diving deep into scenarios, So hopefully the more questions, the more Kisah Benar stories that we can get through PPC is going to be helpful. Tell us your challenges and how you overcome it. We like to hear your stories. And this is where I think then, collectively, when we get the data, if we don't do this and turn this around within the next 2 to 3 weeks, we've lost the game, okay? So I think Dr. Tan there is spot on. We need to do this fast. We need to do this decisively. So this December 19th, please stay tuned. And we hope that, we can pull this off, because it's very challenging trying to do a session of this nature. It's been keeping me up in the nights trying to figure out what they're going to say, what we're going to do and all that, when really I don't have a clear roadmap. So with that, I'd like to thank everybody. I'm going to close the session. Thank you very much to the organizers of Garis Pixel, and also Naini and all the team and Mimi for having been able to put this together this morning at such short notice. So again, I encourage more people to join PPC. Please come in. Look, these are the exciting times. Please jump in and contribute. We need more hands on deck. And thank you, Joseph, for volunteering to do to do more for us. Thanks for bringing your hand up. So one big hand for Joseph as well, because he's not here with us. Yeah. Thank you. Bye-bye. Have a good weekend.
Before that, can we have a group photo?
Oh, sure. Let me unshare, okay? Yeah.
Okay, so we have 2 sessions. First with panelists first. Okay, Firdaus, can you screenshot? Okay.
Mimi, come on, Mimi.
Panelists first, and then after that is tag team.
Okay, 3, 2, 1, smile. Okay, one more, 1, 2, 3. All right, technical team.
Okay, tag team. All right.
Thank you. Thanks, Anthony. Good job.
Okay. All right.
Thank you, Mimi.
Okay.
Smile.
Wait.
Mimi, come on, Mimi.
Mimi.
Yeah, okay.
Okay. Okay, 3, 2, 1. One more, 1, 2, 3. All right, cool.
All right. Thank you, guys.
Okay.
Share the pictures in our group.
Okay.
Okay.
Thank you, everybody. Thanks for taking up your time and doing all the work.
Bye.
Yeah, thank you. Bye.
Thank you,
Bye.
Lillian. Thank you.
Bye.
Ezumi. Have a good weekend.
Same to you. Bye.
Bye-bye. Thank you.
I woke up, I want something to do the slides again. Cannot sleep.